coming through from the audience. So thank you very much to those of you who have put forward questions. You can put forward questions in the chat function, or also we are taking questions that are coming through in the Facebook Live as well. So we have a question that has come through from Craig. What are the MFR requirements for a trust?
So can I be joined by the manager of our financial assessment unit, Natasha Denniswella, who will assist in answering some of these particular questions around MFR.
Hi Natasha, thanks very much for being with us as well.
Thank you for letting us be a part of the opportunity.
Fabulous. So question is, what are the MFR requirements for a trust?
Okay, so the difference between annual reporting and MFR, they're separate requirements. So for annual reporting, it's just based on the trust structure because it's a trading entity. But for MFR, we will only ever license the trustee company. It's the legal entity, whereas the trust is not a legal entity. It can't be sued in its own right. So for MFR, it would be the net tangible assets based solely on that trustee company, and that's usually your paid up capital of $2 or $10 or whatever the case may be. And usually in most cases, a trustee company will need to rely on a deed from a director or an associated company. And then the current ratio is based on the combination of the trustee and the trust.
I think this one is along those lines too, Natasha. It might be one that you can help us out with further. We have someone on the line who has 2 licenses, and these questions might be a bit specific, but do your best. 2 licenses, one in glazing and one for the person personally and one for the business, which is a trust. Do we have to submit 2 annual reports?
Yes, so the company will definitely, because it will contract with the public. And for the director or nominee, it depends on whether that director or nominee has a contractor's license, meaning they can contract in their own right as well as the company. So yes, the contractor's license that's held personally will also need to submit annual reporting information, albeit that their income may be nil. They may only ever get a wage from the company.
I think I'll add there that that's been a source of some confusion, I think, in that first round of annual reporting, that people have felt, well, I've lodged for my company, so I'm done. And why am I continuing to get notices and reminders to lodge? And that's usually because the individual also has a grade license in their own individual name, and both contractor grade licensees, the company and the individual, both need to lodge the annual reporting.
We have a question that's come through that's relevant to the COVID-19 pandemic as well. We have a viewer who has received JobKeeper payments, so that's something that we have seen a little bit of ourselves with those industry participants receiving JobKeeper payments. The guest would like to know how does the receipt of those JobKeeper payments affect revenue from a MFR perspective?
It's also a very common question that we're getting from industry as well at the moment, on the concern that perhaps that JobKeeper payment or any subsidies or grants that get incurred may affect the maximum revenue. It may push them over that threshold. But just bear in mind, to get a JobKeeper payment, your income will be substantially lower. So your income would have dropped by about 30% to be able to be eligible for that JobKeeper payment. So it's very unlikely that that would push you over the maximum revenue threshold.
Thank you very much. We have a question from Shannon Rowe. He asks, partly a comment as well, his observation is that there's going to be a lot of builders under financial stress over the next period to come. He would like to know if there's any mechanisms for licensees to work with the QBCC prior to there being difficulties to receive a helping hand or to guide them through that period. I know, Michael, you've done some writing about safe harbour But from the QBCC's perspective, what do you anticipate over the next period of time in that respect?
So I think I'll kick off and then Nat can talk about the specifics. But I think in terms of, as a general rule, if a business feels that they're about to breach, they're concerned that they may be breaching the MFR, the best thing to do is actually to either contact us sort of proactively and or go to their accountant as well. Now is a good time when you're going to the accountant anyway for tax. Talk to the accountant about the minimum financial requirements and the rules, the NTA and ratio rules. And if you're not meeting or concerned that you might not meet, what steps can be put in place. So we're happy to talk to people who want to ask specific questions. Nat and her team, they're very friendly and approachable. So please do feel free to contact us, or so you can just write in through the contact page, or you can call the call centre, and they'll what they do is typically they'll take an inquiry and someone will call back in a few business days.
Sorry, one of the things that I always say, there's 3 rules when it comes to this sort of stuff, is be transparent and honest with the QBCC, be transparent and honest with the QBCC, and be transparent and honest with the QBCC. So that's rule number. They're my three rules that I just totally believe in, not just because of my background. The other thing that I just point out is that there's a little safety net in place at the moment the directors should be aware of. And I'm not a lawyer, so I'm not going to be outlining this in terms of the legal situation, but the corporations law was amended for a 6-month period, which gives directors protection for debts incurred in their business in the ordinary course of their business during this particular 6-month period. So that was amendments to the Corporations Act by the Federal Commonwealth Government. So I think it's a good opportunity for directors to right now to be sitting down and evaluating and talking to their accountants, particularly their accountants right now, in terms of and getting talks underway with the QBCC, because it's that 6 month has got a drop dead expiry, or it could be extended, but I think it's the 24th of September off the top of my head. So it's worth talking. It's worth talking. I can't repeat it.
Yeah, and particularly for the Category 4 to 7 licensees. Yeah. So as I touched on in the talk that I gave at the start, for SC1 to Category 3, they were given till the end of this year to comply with MFR. There is another reporting date coming up, and then they, so if they think they're not meeting and they're concerned, raise those concerns. Ideally, when you see your tax accountant, just as your normal visit, to talk about that. And then if there's still concerns, then talk to us about what they are, and we can work through those with the person.
Yeah.
We would always say to anyone that asks, running a building business, you always need a good accountant in your back pocket. You do need a good lawyer in your back pocket. Hopefully you won't need to use them, but you'll definitely need to use your good accountant. So please don't leave that to you of your own devices.
Yeah, great advice.
We've got a more specific question from Anonymous. I trade only through my company license, not my personal license. So what do I actually report for the personal license? There is zero income from trading.
That is exactly the answer. Zero income, zero revenue. You would still need to hold the minimum assets to maintain that license. Or if you don't ever contract in your own personal right, you only ever contract through the company, at some stage you could consider downgrading that license to a nominee license to save the reporting obligations.